Right. Right.
So.
No, I think it's been a good discussion. Is there anything in particular with? I know we got some dates coming up with our 2A cases. Guardian Arms. We have
Depositions that are forthcoming. We're in the middle of discovery, and we're looking at filing what's called cross motions for summary judgment, probably in early fall. So once discovery closes and we've kind of briefed up the case, we've put a lot of money and time into experts, and we've got some depositions that are noted for our experts and for other folks. And we're going to, once those are done, I think we'll kind of be done with that phase and really, again, back into what we did in Gators was win on the motion for summary judgment. And so we may be able to do the same. I'm hopeful with the evidence that we've put forward. I mean, I still think that the constitutional question is pretty straightforward, but with Gators preceding Guardian Arms, and Gators is the large capacity magazine, I hate to call it that, and then Guardian Arms is the assault weapons ban. So with Gators kind of at the foredge, we may see that really helps lead the analysis of the judge in Guardian Arms case. So Guardian Arms is in discovery. Gators, we've got the motion for stay that the Supreme Court's going to take back en banc later this month, about a week and a half. Review that, overturning the motion for stay, and if that is overturned, that would then put us back into place where the magazines can be sold.
Right.
And so it'll be interesting to see where it goes. Certainly could see the Supreme Court upholding the stay, and just because that's where we are, it wouldn't surprise me. But I think the arguments that we've advanced are adequate to show reason to dissolve the stay.
Right. Right. And that's the hope. But what we're looking toward the future is eventually going to the Supreme Court of the United States. And so there was a couple of decisions that came out recently that had to do specifically with Second Amendment stuff. And it seems like what we thought was coming down is going to with the most recent denial of, I think it was the assault weapons ban out of Illinois. The Supreme Court denied to hear that case. And the dissent from Clarence Thomas was basically once these cases go a little further and have their day in court is when we'll put them together. You think that when that happens, our case will be pulled up into that, or what would it take to be part of that that decision?
Well, I mean, it's certainly altogether possible that we could be one of the leading edges. It's hard to tell. It's hard to tell what more the Supreme Court wants. I mean, we have experts, we have strong litigation. I don't know what more we could give other than going up, then down, then up, then down, which really is all about the appellate record and maybe filling in some loose ends. But I think realistically, especially when you look at where Guardian Arms will be by the end of the summer, like, what more record do you want?
Right.